The next case is Memorial Health Systems versus the State of Teasley. Ms. Stacy, if this was your first time, you did a fine job. Congratulations. We look forward to seeing you both back.
May it please the Court, my name is Richard Warren on behalf of the appellant Memorial Health Systems, Inc. We have raised two issues in this appeal. The first involves the propriety of the admission of the medical bills, and the second involves the excessiveness of the verdict for non-economic damages. Some background, I think, is necessary to understand both of these issues. Mr. Teasley was 75 years old, and between the period of July 2000 and January 2001, was in the care of three different facilities. Memorial's Ormond Beach Hospital, his facility, Peninsula, which was a rehabilitation center, and a nursing home. He spent approximately 32 days out of that 6-month period in Peninsula. The first admission to Peninsula was for rehabilitation of his right leg, which had been amputated. The second admission was to install a feeding tube because he was not eating properly. And the third admission was for a multitude of problems of diabetes and pneumonia, and he died 3 days after that last admission. The plaintiff offered the medical bills for the entire time that he was at Peninsula. The defense objected. The defense objection was, you must show that the bills were caused by our negligence. And the negligence in this case was solely related to the development of pressure sores, mostly on one sore in his coccyx, and another sore in his left heel, which developed during the first two, but apparently resolved by the time of the third. The plaintiff said, never attempted to say that these bills were caused by the pressure sores. Their theory was, well, you provided services negligently, therefore the jury is entitled to determine what portion of that medical bill was for services negligently provided and give it back to us. The problem is...
Let me ask you this. I mean, aside from the fact that there's tort that emanates from this relationship, isn't there a contract, too, between the patient and the facility that they're going to provide a certain level of care in exchange for pay, and just like any other breach of contract, if you don't perform, is not one of the remedies to retain the consideration that would have gone the other way?
That would certainly be a good theory for them to plead, but they didn't.
Well, it seems that they argued that to the trial judge, and the trial judge accepted that, and so did the jury, right?
Right, but it was not pleaded in their complaint. Their complaint just says we want the expenses that result from the injury, from the pressure sores.
Does the complaint kind of roll with the evidence at that point? I mean, does it?
No, if you want to say that something is tried by consent, there has to be a lack of objection. In this case, there was an objection, so they can't do the tried by consent argument, which they haven't raised anyway, but they, that would not be appropriate because there was an objection to these bills.
Well, do you have to show prejudice? In other words, if they didn't plead it, but it came into evidence anyway, and they won, the jury accepted their argument, which is the argument that they made. Do you have to show that the failure to plead caused you some prejudice?
No. In the tried by consent thing, once you object, that's the end of the story. If you don't have an objection, then you get into the prejudice issue. But the objection eliminates any possibility that they could argue that this issue was tried by consent. And in fact, it wasn't. Well, yes. And again, because the only issue was, did this result from the pressure sores, the bills were not probative until they could identify in those bills services that were rendered to treat the pressure sores, and there are none. I mean, the bills are for room and board, they're for insulin, they're for chest x-rays, they're for lab work, there's nothing in there about treatment of pressure sores that I could find, and they certainly made no attempt to allocate those to those particular items of damage. And as we point out in the brief, it is their burden as a plaintiff to allocate the specific expenses due to the negligence or caused by the negligence of the plaintiff. And the case that is on point in that situation is the Albertsons versus Brady case, where the court reversed because the testimony of the doctors did not associate each medical bill with the injuries resulting from the accident. The court said they may be unrelated. It's the burden of
Were those bills the bills of that doctor, or were they bills of other providers?
I think there were several bills of different doctors.
I mean, this is a little different because these are all bills from your client, right?
That's true, but each doctor, they said, had to identify.
And they're basically saying they don't want to pay your bills because you didn't do what you were supposed to do, right?
That's right, which would be an interesting theory to try on a contract, but this was a negligence case from the outset. Even if those bills were properly admitted, we have the issue of the amount. The bills that were Exhibit 2 in this case were $46,000 approximately. The counsel agreed that the jury would get an exhibit that listed the amount that was actually paid by the insurance to the hospital, which they're entitled to do, of $25,811, and that exhibit was substituted. When the jury came back, and of course the counsel argued to the jury in closing argument, he listed the amounts. These are the bills. We know they did some things right. We know they did some things wrong. Award us a fair amount of this $25,000 that you think was rendered for services that they did wrong. And of course the jury came back with $50,000.
So your argument is that in closing, opposing counsel specifically requested that the jury award them $25,000 or $26,000, and that the jury is thereby bound by that request?
No, I'm not saying it's bound by counsel's request. I think it's bound by the evidence. And the only evidence they had as to the amount of the bills was the exhibit for $25,811.
You would concede that simply because counsel argues for a certain amount that the jury can award something more, right?
Sure. I'm saying just simply to point out again what the evidence was. This was it. And we cited a couple of cases where, and even in Hollins versus Perry, this court reversed because the medical expenses were undisputedly $35,000, but the judgment was for an amount in excess of that. And the court reversed and remanded for the entry of a proper judgment in the amount justified by the evidence, which in this case is going to be $25,811. Now, our second issue has to do with the non-economic damages awarded by the jury, which was $258,000 for pain and suffering over the course of the admission caused by pressure sores. That is not coincidentally, we believe, a multiple of the medical expenses of $25,811. Multiplied that by 10. We are saying that that is excessive and should be reversed, or the order denying the new trial should be reversed for two reasons. First of all, that award is not supported by the evidence.
What's our standard of review on this issue here?
Abuse of discretion. As the trial court does, the discretion is going to be based on whether the verdict is unjust, whether it shocks the judicial conscience, whether the jury's been deceived.
Why should that shock my judicial conscience?
Well,
why should that amount shock my conscience?
Here are the factors. We have one reported instance of pain during the entire 32 days in his coccyx. Now, he was in there for a number of conditions and suffered pain from a number of conditions and received medication for a number of conditions. Second, he had 35 other instances of pain not related to this. So the ratio, even if you accept their argument that if there was one instance of pain, there must have been others, certainly the ratio of his...
So because he had one instance of pain, that amount is just outrageous and should shock my conscience?
That's one argument, yes. That's one issue.
What's your other argument?
The other factors are the period of time in which he suffered the pain. He was there for 32 days. He had this one instance. It was apparently, as the experts say, relieved by medication. Secondly, I'd like to point out, again, because the award is so greatly in excess of the medical expenses and appears to be a multiple of it,
That's, I mean, it appears that way, but you can't say that that's how the jury calculated that. I mean, that's speculation on your part, isn't it? You don't know that.
No, I don't. And it is, but I think it is a factor to consider.
Well, they awarded 50,000, so if they were going to use the 10 multiplier, they should have given 500,000 for pain and suffering.
Well, we say they multiplied the medicals too.
They used one number for one purpose and the other number for another purpose.
Well, we say they multiplied it by 2 for the medicals and 10.
I mean, do you really expect us to reverse based on that argument, that speculation that, you know, that was a multiple, and you don't know that?
No, I'm saying that is something to consider. But I think that the real point is,
So we've got one instance of pain. He was given pain medication, and he was somewhat relieved of the pain. And then your speculation that there was some sort of multiple calculation by the jury. What else? What other reasons can you present to me as to why that figure should shock my conscience?
I think the other issue is, of course, the sympathy that the jury had for his condition. And this goes not to the shocking the conscience, but whether the jury was influenced by passion or prejudice. And I think in this, and I'm comparing this case to the University Community Hospital versus Martin case out of the 2nd District, which had a similar situation because the person was in the hospital as a paraplegic, and he suffered other injuries in the hospital. And the jury awarded $350,000 for his subsequent injuries. And the court reversed and said, addressing the same factors we have here, there was a pitiable condition. We only have a limited instance of additional damage caused by the hospital. We have an aggravation instruction as we had here. So the court in that case said that that the award was excessive and reversed. So in addition to the sympathy, this pitiable condition, the one instance of pain during 32 days out of the 6-month period, we think that the award under this case, University Community Hospital versus Martin, is excessive and should be reversed, and we believe should be remanded either for a new trial in damages or for a remitted of $50,000, which was the amount awarded in the pretrial non-binding arbitration.
Thank you, counsel. You've got about 8 minutes left.
Good morning, Your Honors. May it please the Court, my name is Susan Morrison. I represent the estate of Joe Teasley. This case can simply be summed up insofar as stating that the appellant has failed to meet their burden of a reversal. And frankly...
How about the difference between the $26,000 or $25,000 and the $50,000? What's your response?
Your Honor, I can't, as I sit here, as none of us could, tell you why the jury awarded $50,000. The plaintiff did not ask for some certain. He put into evidence the medical bills, and by the way, counsel did not say this, but he objected. The scope of his objection was, we did nothing wrong. We object to all of these bills. That was overruled. His second objection was, well, if that's the case, then we should only submit the amount paid, not the amount charged. We had in our original exhibit an identified list of items and charges from the hospital. Counsel stipulated to the use of a summary and then criticized us for saying that the jury was unable to discern between which services were rightfully provided, which were wrongfully provided. We suggest that he invited error.
Why were you entitled to recover more than you paid?
Well, Your Honor, whether we are or not, I can't answer that question, because the bottom line is it was within the purview of the jury to award damages. The admission of evidence, we believe, was proper, because this wasn't an issue, contrary to what counsel said, of he was in here for all these pre-existing medical conditions, and all we did was cause one bed sore. That's not at all what happened.
Okay, well, set that argument aside just for a minute. Okay?
Yes.
I'm more interested in, this is compensatory damages for medical expenses, and the jury knew that your client only paid $25,000, even though the appellant charged $50,000. How can they legally award more than what was paid?
Well, I would suggest, Your Honor, that whether they could or not, that issue was waived and that by the defendant, and that the defendant invited error by first not objecting to the submission of the summary of bills on that basis,
But I thought the summary of bills was
Yes,
25,000.
you're right, absolutely right on that point.
Judge
But-
Torpy's question goes to the difference between the 25 and the 50.
understand.
Let's dispose of that first.
And it seems to me incumbent upon the defendant to then ask for jury instruction that the jury allocate the appropriate bills relative to or caused by the conditions
That
that they
doesn't make
found.
any sense if we've only got, if the only evidence is for $25,000, why does he need a jury instruction on the difference between 25 and 50?
Well, because the jury instruction that he consented to was the jury, if you find negligence, the jury is entitled to award the reasonable value of hospitalization expenses. And counsel agreed
Yeah,
and
but you
stipulated to that.
can't recover, when we're talking about compensatory damages, you can't recover that to which you're not obligated to pay.
Your Honor,
And it's your burden to show that this is a loss that I sustained and I'm entitled to recover it. And if the other $25,000 was not a loss that you were able to prove by preponderance of the evidence, you're not entitled to that money.
I would agree with that, Your Honor, but again, I would suggest that defense
And how did you
counsel
prove
invited
that?
error on that point by admitting into evidence the records of the subsequent nursing home stay and the prior hospitalization and nursing home stay to show we didn't do anything wrong. If anything, these other people did it all. And counsel argued.
You've admitted before that you're not obligated to pay the additional $25,000. It may have been 26, and I'm not exactly sure of the figure, but there's a difference between what you established in your closing argument, or at least by your summary, and what the jury awarded. And you didn't approve that. You did not prove you were entitled to that additional amount. If you're not entitled to it, you shouldn't recover it.
I agree that we didn't prove any additional amount, Your Honor. However, I would suggest that
But you're saying that because they didn't make a specific objection as to that additional amount, that they waived it?
not just that they made no specific objection, that they invited error by putting into the record the medical records of these other facilities and blaming it on other people, and then compounding that issue by suggesting.
How did that factor into the additional $25,000?
Because they subsequently agreed to an instruction which said that the jury could award the reasonable expenses of hospitalization without limiting those to expenses incurred in this particular facility.
Did they introduce evidence of the value of those subsequent admissions?
I don't believe, well, I haven't looked at the records directly, but counsel said in his brief that they were simply the records and not the dollar amounts, and I have no way to know.
Speculation then on part of the jury.
So the only evidence the jury had was on the 25K.
Yes, sir. And at best, the court could have remitted to the $25,000, but did not do so. But the issues, as far as we're concerned, are, if I can move on to the other issue,
Well, maybe you ought to move on to the question of whether you can keep the next 25K.
well, I'd rather keep the next $258,000 with all due respect, Your Honor.
Fair enough. Your decision.
The pain and suffering issue, counsel argued that this was a simple case of a simple bed sore. His first admission was for rehabilitation of his amputated leg. The issue in that particular resident period of admission was they did nothing for this man, and he not only developed bed sores and worsened existing rashes, they didn't treat him for almost the entire time he was in during his first period of hospitalization, didn't assess him, didn't give him a proper bed, didn't give him range of motion. He was in there for rehabilitation. He was not dying. He was expected to be fitted for a prosthetic limb and trained to walk. And because they did no range of motion, they didn't turn and reposition him, the man developed contractures and was not able to walk again. He also developed bed sores due to their failure to do toilet training. And he also had dehydration issues and malnutrition issues throughout each of the stays. The second stay, counsel said, all we did was insert a feeding tube. Well, during that stay, the man developed had worsening of his malnutrition. Well, if you're going into a hospital to get a feeding tube inserted, one would think that it would be part of their duty to also ensure that you have proper nourishment being added into that tube. That was during the second stay. During the second stay, he also, they failed to skin care plan. This is a man who had PVD. He had, decreased circulation in his legs. He had advanced 20 years of diabetes, they were on notice that this man was at exceptional risk of skin breakdown. They did nothing during any of the 3 stays to prevent him from developing sores, to prevent sores from worsening from prior sores. And as a result, in each of these residencies, it wasn't a simple one sore. There were contractures in the first time, there were coccyx ulcers, and he came in with a simple rash on his bottom. They didn't treat him, they didn't care plan to assess that, they failed to turn him, and of course, lo and behold, that turned into an ulcer. During the second period, he was in there for 5 days, as counsel said, to get a feeding tube, and he had, again, no assessment of his ulcers. They failed to remove the bandage off his ulcers for a period of 5 days. Didn't do one thing during that residency to treat his ulcers. And they failed to assess and treat nutrition and hydration issues, both of which contribute to the worsening of pressure sores, not to mention the malnutrition factor. During the third period of residency, he was admitted with dehydration again and had worsening of his sores, and they again failed to do anything to treat this man. Failed to treat him, failed to provide him with the proper bed, failed to provide him with proper water, failed to assess the intake and outtake of fluids, all of which resulted in the worsening of all of his conditions. So this wasn't a simple case of one bed sore and he only complained once. And let me talk about the pain assessment for a moment. It was the plaintiff's theory at trial. The court agreed with it. The jury agreed with it. The court, on motion for new trial, didn't disturb the jury's verdict. That the reason that there was only one notation of pain is because there were holes throughout this man's chart where they just didn't write anything down. And the one assessment of pain was, on a scale of 10, a 9. And our experts testified that there's no way that a man who had pain on the scale of 9 to 10 would never experience pain again from that same spot. And the reason that there was no notation is because there was testimony throughout the trial that this facility was terribly understaffed. Counsel's entire defense at trial was, we did nothing wrong. We took care of his diabetes, we took care of his contractures, we added a feeding tube, and all these other places caused his wounds. We did nothing wrong. So the pain assessment is a red herring, and the testimony supported the jury's finding as the judge determined. The burden is clearly on the appellant to make a clear showing of abuse of discretion, and they have to do so with record evidence. This appellant did so with speculation, as Your Honors noted, with the 10 times and 2 times and 5 times. There's just no evidence in the record of any of those issues, nor is there any evidence in the record to support their assertion that the jury verdict is against the manifest weight of the evidence. The trial court in this regard is given broad discretion with regard to the grant or denial of a motion for new trial, and it's appellant's burden to show that he abused that discretion. And applying the reasonable person test, it cannot be said that a reasonable person would determine that if reasonable persons can differ as to the propriety of the court's action, there can be no finding of an abuse of discretion. And counsel's entire argument on abuse of discretion in the context of manifest weight of the evidence is speculation based on his, one pain assessment and his people saying that coccyx sores don't have pain because you don't have a lot of nerve endings on the lower part of your back. Well, the man said he had a pain on the one that was documented of 9 out of 10. So apparently that was not found to be credible by the triers of fact. With regard to the excessiveness of the verdict, it must shock the judicial conscience or be shown to be that the jury was influenced by passion and prejudice. Counsel for the defense was actively involved in voir dire process, had every opportunity to question these prospective jurors about whether they would be motivated by prejudice, and there's nothing in the record, nor has counsel cited anything in the record, to support that entire line of argument whatsoever. So we would ask that the court disregard that. With regard to the shocking judicial conscience aspect, the trial court, again, is afforded broad discretion in determining what's appropriate in his conscience. And generally speaking, judges rely upon community standards and community verdicts in other similar trials in nursing home and hospital cases. And we would suggest that $258,000 for a pain and suffering verdict based on the gross neglect that this man suffered and the fact that he went into that facility in the first place for rehabilitation of an amputated leg, and he ended up dying several months later and was never able to ambulate again because they allowed his leg to be contracted, his other joints to be contracted. They allowed him to lie in waste and feces and not train him in bowel and bladder training, which took away his dignity. They allowed sores to develop and rot his skin. And then they say, well, he only complained of pain one time, therefore the jury verdict is excessive. With regard to the cases cited by counsel, the Albertson case is distinguishable, as is the UCHB Martin case. In Albertson, the holding was, in the state of Florida, you don't just submit medical bills, you have to have something more. And the something more in that case was simply the plaintiff saying, yeah, they're my medical bills. There was no nexus whatsoever to injuries or incidences and those medical bills. And the court in that case, the second district, that was 1976, said that's not enough. That same year, the Florida Supreme Court decided Garrett. All of these cases are cited in our answer brief. The Garrett court said that you don't need a medical expert, that you can admit medical bills merely by the plaintiff's testimony. You just have to tie it causally. In this case, and subsequently the second district in the case of Easton a few years later, said, based on Garrett, that a plaintiff's testimony linking treatment to therapy is good enough. In our case, we had the plaintiff's testimony and we had the testimony of several experts that said this wouldn't have happened but for their negligence. The contractures wouldn't have happened but for their negligence. The malnutrition, hydration issues would not have happened but for their negligence. And those two, even though they're independently actionable, also were the cause of the worsening of bed sores, because any medical professional knows that if you have compromised nutrition and compromised hydration, that even if you're not diabetic, that is going to exacerbate issues relative to skin breakdown. The UCHB Martin case was a paraplegic case where a man had been shot in the spine and he had virtually no chance of recovery, but he had some feeling in his foot. Not that he was going to be rehabilitated, but he had some feeling. Then they dropped it, and he lost some of that feeling. The appellate court reversed the jury's verdict saying, well, he had a condition that, from which he would never improve. And even though there was some damage, we think that the jury erred not in finding liability, but I think liability was actually consented to in that case, but that the jury disregarded the evidence and awarded too much money. That is completely...
I'd like to go back to the medical bills for just a minute. If, and I'm not saying that this is how we're going to rule, but if we decide that you're not entitled to the difference between the 25 or 26 and the 50, does it go back for, would the appropriate remedy be for us to reverse it for a new trial on compensatory damages and limit it to just the medical bills, or for us to say that the most that you're entitled to is the 25 or 26?
Your Honor, I think the latter is the proper remedy, because the bills are what they are, and I don't think a new trial is necessary on that because there's no discretion. And if the court determines that $25,000 is the number, then I think you can remand to the court with instructions that he grant the remitter, because they did file an alternative remitter just on the $25,000.
Well, I'm still having trouble with the first $25,000.
That's what we're talking about, Your Honor. And I concede the problem. I understand the issue. I researched it, and it troubled me. But, I did find error on defendant's part, and
I think essentially what they're requesting is a new trial concerning the issue of the medical bills, the compensatory damages as to the medical bills. Obviously, if we reverse on one and we affirm on the other, you just get the new trial on the one item of damage.
Well, Your Honor, I don't think...
Isn't that basically what they're looking for, is a new trial on the medical bills?
Well, I think they might have asked for that, but they asked for a remitter in the alternative, and frankly, there's no jury issue on the issue of the medical bills. If this court determines that the plaintiff was not entitled to any more money than the face amount of the bills paid, then that's just a math calculation that the trial judge could do, and there's really no jury issue there.
Well, in order to be entitled to the face amount of the bills paid, in a negligence case, there would have to be a conclusion that everything that was done to him in those 3 admissions was related to negligence. And what evidence is there of that?
Well, Your Honor, that's what I was saying. Everything that was done or was supposed to be done from this person, including the insertion of the feeding tube, I don't think there's an issue as to whether the tube was inserted properly, but what did they do with it once it was inserted? His malnutrition continued while he was in the hospital, supposedly getting treated for malnutrition. Same thing with the leg. He was in there for rehab. Did he get any? No. They didn't do anything for this guy, and instead his leg became so contracted he couldn't be rehabilitated.
Well, but that sounds to me like a restitutionary claim. Give me back my money. I paid you $25,000 for care. You gave me Zippo care. Give me my money back.
And Your Honor, that wasn't.
But that's not how you measure damages in a negligence case. As you already previously said, there has to be a causal connection between the damage caused by the negligence.
Well, Your Honor, I think the jury did find causation. They just awarded a number that they, who knows where they got it from. But it seems to me that our entire argument throughout this trial was, we don't care what they charged us, we don't care what they said they did or what they were supposed to do, aside from the treatment of this bed sore or several beds, so there were quite a few of them, by the way. We're saying they didn't do a thing they were supposed to do for this man, including feeding him when he had a feeding tube. The jury obviously agreed and gave us not only all the money back, and, they gave us more money. And why they did that, I can't tell you. But it seems to me that at best, this would be a trial by consent, and I totally disagree with counsel in terms of how that should be presented. Number one, insofar as the objection
Well, if there was a theory that you should have pled that you didn't plead and you won anyway on that theory, don't they have to show prejudice in order to?
Yes, Your Honor. We believe they have to show prejudice, and we believe they tried it by consent. Never objected, nor did they argue to the jury that they should isolate the portions of good care that were provided from the rest
Well,
of
it
the
looks to me like they did. I mean, there was a very specific discussion in the trial about this, where the statement was made. I can't find it now.
I have it, Your Honor, if you'd like me to. On page 803, they were talking about, no, that's the closing argument, and that's part of the thing. This is all defendants said at closing argument.
Judge, my whole case has been that the hospital did not provide the care they should have on all 3 hospitalizations. I'm just seeking to admit the bills of the hospital and my client was charged for care. We claim he did not receive. That's a restitutionary claim. In reply, Peninsula said, Your Honor, we have not heard one single witness say those bills were causally related to any of the injuries we may or may not have caused. And the trial judge overruled the objection. I mean,
and the reason the trial judge,
it's perfect. I mean, both of you did your jobs.
The reason the trial judge overruled the objection is because there was testimony from our experts that they didn't do their job all across the board. We had nursing experts.
But that's not the point. The point is that they had to show that that every bill, every item of charge was for care causally related to the negligence.
I agree with that, Your Honor. And our position is everything they did was negligent, whether it be for the rehabilitation of his leg, whether it be for the feeding tube issue because the man was malnourished, whether it be for giving him fluids. Everything they did, our experts said, it wasn't just a bed sore issue, ladies and gentlemen of the jury. This was a situation where these people just stuck him in a bed and ignored him. But at closing argument, counsel said, I've submitted and given to you broken down hospital bills. Oh, I'm sorry, that's plaintiff's argument. Defendant's argument was limited to 2 sentences. The medical bills would only come into play if you found negligence. That the negligence, but for the negligence, this would not have occurred, and then you get to talk about damages. I would submit to you that the proper verdict in this case would be no negligence. Please check the first mark. There was no comment to the jury. There was no objection to the jury charge during charge conference.
They don't have to.
I think my time is up, and I would respectfully ask that the court affirm in all respects, or at a minimum, just reverse insofar as the medical bill is concerned, with instructions that the court enter a verdict in or a judgment in accordance with the actual amount of the bills paid. Thank you, Your Honor.
Thank you. All right. Go ahead. Yeah.
To be practical about the issue relating to the medical bills, if we reverse on that point, you're going to go back and settle for the $26,000 anyway. I mean, you've alleged basically two claims of relief. One, that we just reversed and sent it back for a new trial on the issue of medical bills, or two, based on the remitter, that we say that it should have been $25,000.
Right. Yeah,
Practically speaking, I mean, isn't the second remedy basically what you're looking for?
right. Yeah, the second remedy would be simply to remand to instruct the judge to remit it to $25,000.
And that's really what you would prefer we do, right?
No, I prefer you strike the whole thing. Based on,
Well, I'm talking.
just on the second issue, sure.
Okay, I'm talking about just the issue as to the medical bills.
Correct.
Right.
That's
So
the
you,
way to do it.
pardon?
Going back to the remedy on the first issue, if you reverse on that issue, I know we said in our brief we should get a new trial on damages. However, I've reviewed some other cases in preparation for an argument that, you have the alternative to simply strike them because the plaintiff did not meet its burden to allocate those damages to show that they were causally related. And that case is a second district case.
Is that a supplemental authority that you filed?
No, it's actually cited in our brief. Yes, it's Smith versus Austin Development Company, 538 Southern 2nd, 128. In that case, the landlord didn't allocate the damages for the build-out, and the damages were stricken. So I believe that that is the proper remedy on the first issue. And going back to the first issue, I'd like to also point out that...
Well, as to the first issue, you specifically requested in your brief a new trial on
Right.
the issue of damages, not that we strike it.
You're
You
right.
say you're entitled to zero,
Right,
but they're entitled to zero.
I think
You didn't
that is-
request that.
I didn't request it, but I think it is an appropriate remedy. I was relying on the Albertsons case where there was a possibility that the doctors would be able to testify as to specific items. In this case, I don't think, looking at the exhibit, that it's going to be possible for them to testify that any of those items for x-rays and feeding tube and all the other things were attributable to the pressure source. And this case is, of course, distinguishable because a hospital doesn't bill for services. And they're saying that they negligently provided services, but there's no item in any of those bills about nursing services. They get room and board, they get various tangible things. So how are you going to say, under a restitutionary theory, if they have the burden to allocate it, how are you going to attribute any of those charges to negligent services that were not provided? Our position in this case would be, and as far as the preservation issue, you read the objection. 90.104 says, once you make an objection, it is ruled on definitively by the court. You do not have to do anything else to preserve the issue. After that, they had to stipulate as to the amount that was appropriate, but there's nothing that says after that objection.
Did you stipulate to the amount of, was it 25 or 26,000?
Stipulated to the amount.
All right, and so you said that would be the amount that would be appropriate for them to request compensation from the jury for.
Right. After the judge overruled the objection, they said, okay, now we're going to go on to what the amount is, and this is the appropriate amount. Thank you.
Thank you.
Okay. Well argued, counsel. I think